The Senzo Meyiwa murder trial today being postponed to the 2nd of May 2023 to allow a new representative for accused 1 and 2 to familiarise himself with the case. Let's talk about this with Nthabiseng, Dubazana, a legal expert. Very good afternoon to you, Nthabiseng. Thank you so much for your time today. So, mid-trial, 2 of the 4 accused now getting a new attorney. How significant is this?
It is very huge because now it means that there's going to be delays in the matter. It means that now the new attorney has to now go through the transcripts, have to go through the documents, or rather the dockets that has been given to the other attorneys in this matter thus far. So which means we're going back to pre-trial when we were now going through all the documents and then familiarizing us with the document in order for us to prepare our clients to do a better job for them under cross-examination, etc., etc. So this is now a huge delay in the process because we have to deal with the time frame it's going to take to do the transcripts and then the time frame to do consultation. So yeah, that's why it's quite significant.
And is it a reasonable length of time? I mean, we're in November now. Obviously, we had about 2 weeks more to go of this part, but is postponing to May reasonable considering all that needs to happen in order for the new legal rep to be fully appraised of the situation?
I believe it is. I think the main issue would be the time frame required to get the transcripts ready, because we are now going into recess very soon with the courts. So that would need to be done in such an expedited situation so that the records can be made readily available. And then the presiding officer, the new attorney, will then take the said records and then take them to a transcriber in order to get those to the transcripts ready and go through them and familiarize himself with it. Then go through the docket and go to the place where the accused persons are being held in order to have consultations with them and prepare any cross-examination is going to come with the new witnesses that are coming and all of those things. So I think up until May, it's sufficient time, maybe a little bit more than necessary, but it's sufficient time.
Just on the issue of upcoming witnesses, the state has played its cards very close to its chest as far as who we're going to hear from next. Is that really warranted at this stage in the game?
I think mainly because the trial is being aired, that is the issue. We don't want a situation where, for example, we know today that maybe a Kelly Kumalo is going to be testifying today, and then the media is, swarming the courts, and then there's no access, and there's all those access control issues and safety issues that are dealt with. That is, I think, the main reason why the state is playing its cards close to its chest. But otherwise, in a normal situation, we would know as attorneys that who's coming next and all of that, so we can prepare ourselves and cross-examining that person and all of those things. I think it's just for the media not to know who's coming in order to protect the people that are coming to give evidence. And
I wonder if, Nthabiseng, just based on what you're saying, given that there may be witnesses more high-profile than Tumelo Mazala last week, i.e. Kelly Kumalo, the singer who was also the girlfriend of Senzo Meyiwa when he was killed, her sister also in the house, possibly as someone who may be called as a witness in this matter. Do you think the events of the last week, especially the media transgressions from showing the picture when we'd been told not to, the chasing of Tumelo Mazala through the courtroom in the last 2 months or so, do you think that is sufficient grounds for some of the other witnesses to perhaps say they in fact don't want media in the room when it's their turn to testify?
Most likely, but then remember, the court doesn't necessarily have to take that one witness's feelings or position into consideration. It's a whole balancing act. It is not just you that is there. It is now the right for the media to be present within the court. It is now the right to have the matter being heard in open court. We need to now weigh those rights that are in the Constitution versus what your feelings and wants are as a witness. So in that respect, the court will have to be very, very careful and tread very carefully in saying that the media is not permitted to be in the courtroom. If those witnesses say that based on what happened in the past, they don't want media in the courtroom.
More than once, though, Judge Chifua Mamela has said that the trial, or for justice to be seen to be carried out, it does not necessarily have to happen in front of the glare of the media cameras. How much should we pay? How much attention should we pay to that? Do you think he may perhaps even have to balance it with the level of interest among South Africans who want to see that this process is run fairly?
Like I said, it's a whole balancing act, unfortunately. In the times that we live in, the courts had to adapt to media being in court. There's a whole case, it is the NPA versus Media 24, wherein all the logistics were set out in how we need to consider media being present in court. Now, having said all of that, we also have options in court whereby if somebody doesn't want to be within the courtroom setting itself, they can give evidence through a camera in another room, and then they don't have to be, in quotes, violated by the media that are there and, want to take pictures and all of those things. They can testify in another room wherein they're not seen, and then when they're done, they can leave in another exit where they're not going to be seen. So it won't necessarily hamper the matter going forward.
Nthabiseng, Dubazana, a pleasure to speak to you. Thank you.